Well, hello, good evening, and welcome to episode 119 of Fracking Nightmare. And, we're coming up very close to Fracking Nightmares. I believe it's the 5th anniversary, because the first episode went out in the autumn of 2013. And I certainly never expected to still be having to come to the studio, although I don't do it on a weekly basis now, but 5 years hence. Although I will say that I get a very, very strong feeling that we are now in the last 12 months or so, and that's a worst case scenario, of this fracking nightmare, because the industry is very much on the back foot. And this was probably epitomized by an observation made by Lee Rowley, the MP for North East Derbyshire. Now, Lee Rowley is a former oil and gas analyst, and he was also elected on an anti-fracking ticket. The sitting Labour MP prior to the last election was a lady by the name of Natasha Engels, who was pro-fracking, and she got bounced out to the constituency to be replaced by a Tory, Lee Rowley, who is anti-fracking. Now, Natasha Engels has gone on to work for INEOS, obviously deciding that the INEOS paycheck is a lot more lucrative than the parliamentary paycheck. But Lee Rowley has yet to fall into the party line, as it were. And at a fringe meeting at the Tory conference at the weekend, he made the observation that the exploitation of unconventional hydrocarbons, i.e. fracking, is like a barnacle on the bottom of the Tory ship and needs to be removed. And it is dawning on more and more Tory MPs that this is a vote loser. In fact, Lee Rowley made the observation that there's only been about a dozen or so applications to frack or to initiate exploratory drilling since the moratorium was lifted in 2012, and yet the anti-fracking community is the fastest growing social movement this country has seen since the advent of poll tax. Now, Lee Rowley made the statement that the licensed areas cover potentially cover some 200 areas of MPs, and 96 of them are Tory MPs. And in fact, of course, they don't have a parliamentary majority right now. They're reliant on the partnership with the Democratic Ulster Unionists. And consequently, the realization is that if this agenda pushes ahead, the likelihood is that the Tories will definitely lose the next election. Not necessarily if there was a snap election, but in 2022, if some of the government plans are realised, then the Tories won't be in power. And of course, Labour have committed to outlawing fracking should they get into office. Well, actually, the anti-fracking campaign is developing into a lot more than just anti-fracking. It's becoming increasingly evident that we have a civil rights issue rapidly arising in the UK. In fact, it is here. It's just that people haven't realised it yet. And this is a picture from July of 2017, when 4 individuals decided that they were going to surf the trucks heading into the Cuadrilla well site. And the total duration of this protest was some 99 hours. Now, at the time, I made the observation that I sensed that they were being deliberately left on top of the trucks to set up an opportunity to incarcerate them, i.e. to sentence them to jail. And sure enough, these guys were convicted in a jury trial, and they were convicted of the charges, effectively, of obstructing the highway. Well, it was a public nuisance offence that they were actually charged with, which is one that carries a custodial sentence. And the hearing ended on Tuesday of last week, and the sentencing hearing, and the Judge Robert Alton, decided that he would defer his actual sentencing verdict until the following day. So one was hoping that he would actually reflect and recognise that actually this really didn't warrant custodial sentences, and if it did, then they should be suspended. But unfortunately, that wasn't to be the case. And so here's a report from the Guardian. It said at approximately 8 a.m. on Tuesday, 25th of July, 2017, as 7 lorries containing drilling equipment attempted to approach the site, Roberts, a piano restorer from London, got through a police cordon and climbed on top of the first lorry, bringing the convoy to a standstill. Loiseau, a teacher from Devon, climbed onto the cab of the last lorry. At about 3:18 p.m, Blevins, a soil scientist from Sheffield, also climbed onto one of the lorries. And in the early hours of the following morning, Brock from Torquay also climbed onto a lorry in the convoy. Fellow protesters threw blankets, food and water up to the men as they camped out on the vehicles. Loiseau came down on 27th of July at 5:10 after 45 hours. Blevins did the same at 4:45 p.m. on the 28th of July, having spent just over 73 hours on his lorry. Roberts descended at 8:13 the same day after 84 hours, but Brock did not climb down from his lorry until the 29th of July at 11:35 after an estimated 76 hours. So the total duration of the protest was just shy of 100 hours. But to the best of my knowledge, these are first offenders, and of course they were peacefully protesting the attempt by Cuadrilla to frack at Preston New Road. Well, the Guardian continues in its report. It says, sentencing the men, Judge Robert Oldham said he thought the 3 men posed a risk of reoffending and could not be rehabilitated, as each of them remains motivated by an unswerving confidence that they are right. He added, even at their trial, they felt justified by their actions. Given the disruption caused in this case, only immediate custody can achieve sufficient punishment. He went on, he said that while the defendants were motivated by a serious concern for the environment, they saw the public as necessary and justified collateral damage. Well, as I observed in one of my live streams last week, to make that observation is almost extracting the Michael, and certainly a case of some serious reflection, because this is precisely what the unconventional gas industry does in terms of how it regards the public as necessary and justified collateral damage. They're not interested in the negative impacts that this industry causes wherever it establishes a footprint. They just want to get in there and pump the frack fluids into the geology. Well, let's take a look at Judge Robert Oldham, because he's actually also a descendant of the judge who presided over the Pendle witch trials in the, what was that, the 17th century? But here was an observation. Judge Robert Oldham, he jails 3 anti-fracking protesters for 16 months for taking part in a peaceful protest. This is the first time public nuisance has been used since 1932 for protesting, and back then they only got 6 months. And in fact, actually they got 6 months for their part in an affray with the gamekeepers that were sent in to deal with the protesters on the moors seeking access rights. However, the same judge lets paedophiles with thousands of child abuse images on their PC walk free and has a financial interest in the oil and gas industry. Well, he may not directly, but his family certainly has a shipping business which does business with the oil and gas industry. So even on the basis that his family have links, he should have recused himself from this trial. But whilst there have been certainly 3 cases where he has let paedophiles who have had images on their PCs walk with suspended sentences, this is a case I want to particularly refer to, and this is from 2015. A paedophile was jailed for the most shocking images the judge had ever seen, and this is a report from the Lancashire Post. Judge Robert Oldham, sitting at Preston Crown Court, said, "These are some of the most grave and sickening images I have ever seen. Having seen the images of these sort of cases before, I was especially shocked by what I saw. One clip involved a dog and a child," the court was told. The guy who was being charged admitted 17 counts of possessing and making indecent images, but the judge pointed out the charges represented many more images, adding, Those represent an enormous collection of both still and moving images depicting children, either in sexual poses or children engaging in or being subjected to various forms of sexual abuse. All of the children are bound to have suffered long-term sexual and psychological harm. What you need to understand, he said to the defendant, is every one of those images represents a real child who has suffered real abuse. Anyone who downloads these images perpetuates that abuse. So Judge Robert Altham obviously considered this to be an extremely serious, indeed heinous crime. And clearly the defendant was in need of a custodial sentence. So what did Judge Altham sentence him to? 15 months. Just 15 months. Well, in the inimitable words of Judge Judy, this is unreal. This is completely unreal. So 3 men who have done nothing more than attempt to protect the fragile ecology of this country from rampant corporatism get sentenced to 2 at 16 months and 1 at 15 months, which is equal to the sentence that Judge Altham handed down 3 years ago to a pedophile who had some of the most heinous images that the judge had ever seen. So, what the judiciary in this country are effectively now stating is that dissent against the corporatist agenda, peaceful dissent against the corporatist agenda, is the equivalent of paedophilia. And I don't think there is anybody watching this who would actually agree with that. Well, the law of unintended consequences has certainly kicked in. Because, first of all, of course, there was a reaction at Preston New Road. And there was a lock-on that started off on Monday morning. And I think the last people were removed from that lock-on late yesterday afternoon. And then there was another lorry surf today. And these lock-ons and this surf are inside the injuncted zone. So Cuadrilla was not only sitting back on their laurels that the injunction was going to protect them, but the threat of custodial sentences would be enough to prevent people from participating in direct action. Well, the magnitude of those sentences has sent ripples right throughout the country. And I could actually fill the programme with comments from all parts of society about these outrageous sentences. And I know that many people have written to the Lord Chancellor asking that basically these sentences be reviewed. And in fact, 200 academics at Sussex University have called for a judicial review. And this was actually reported in The Independent a couple of days ago. Fracking protesters' absurdly harsh jail sentences spark calls for judicial review backed by hundreds of scientists. More than 200 academics have signed a letter calling for a judicial review on the absurdly harsh prison sentences handed to 3 fracking protesters on Wednesday. An open letter started by staff at the University of Sussex says that the jail terms are between 15 and 16 months for halting a convoy of lorries carrying shale gas drilling equipment set a dangerous precedent. Simon Roscoe Blevins, Richard Roberts and Rich Lazo are thought to be the first environmental protesters to receive a jail sentence in the UK since 1932. I'm not sure that's quite accurate. But nonetheless, the open letter that was signed by the academics is worth reading here. We, the undersigned, 200 plus academics, are writing to express our concern about the shrinking space for communities and environmental defenders to engage in civil opposition to fracking developments in the UK. This week, 3 non-violent campaigners opposing fracking were jailed for 15 to 16 months simply for causing a public nuisance and for not expressing regret. Although others have received jail sentences in more recent times, this is the first time since 1932 that environmental defenders have been imprisoned for such long periods of time for staging a protest in the UK. That is true. It's also the first time ever that activists have been jailed for anti-fracking actions. With fracking companies increasingly granted civil injunctions to prevent protest, the scope of protest is becoming more and more restricted, representing a threat to fundamental rights, to freedom of expression and assembly. Fracking is controversial in the UK. According to government surveys conducted in 2017, only 16% of people support fracking development. I think that might have increased apparently to 18% now, but the number opposing is more than double that. Given the grave environmental consequences of hydraulic fracturing and growing concerns about climate change, this is not surprising. The ruling sets a worrying precedent, curtailing opportunities for the kind of public protests that have historically been effective in instituting the legal and policy changes that defend our environment for future generations. We need more, not less, space for action to confront unsustainable industrial practices that harm our communities and perpetuate our resilience on fossil fuels. We oppose this absurdly harsh sentence and join calls for an inquiry into the declining space for civil society protests that it represents. It's not declining space. There is now no space. Basically, anyone who suggests that we live in a parliamentary democracy is simply not paying attention. And they are simply caught up in the chase to earn sufficient money to keep a roof over their head and food on their table. This draconian sentence is intended to send a message to anyone who wants to challenge the corporatist agenda. Well, the law of unintended consequences, I think, is going to be very, very significant here. And the civil courts are implementing a raft of supra-parliamentary legislation that gives these fracking cowboys carte blanche to ride roughshod over communities and effectively completely shut down any meaningful opposition. So we are on the cusp of effectively being in a civil rights crisis. And my urge is that people actually do take a look at the implications here, because this shuts down protest against fracking. In 2015, in April, the British government amended quietly the Infrastructure Act to give them the opportunity to dispose of pretty much anything they want down deep boreholes without consulting the local community. And then we look at the work of Professor Fergus Gibb at Sheffield University, where he's been working for 20 years on burying highly toxic nuclear waste down deep boreholes. So consider the possibility that basically this raft of legislation is being put in place in readiness for dumping toxic nuclear waste down abandoned or orphaned wells without any consultation with the local community and without any possibility of peaceful protest, because peaceful protest, effective peaceful protest, is outlawed. So we are on the cusp in more ways than one, because we are potentially on the cusp of the first frack in the UK since the moratorium was lifted in December 2012. And of course, that moratorium was put in place due to Cuadrilla fracking into a fault that they weren't aware was there. And that ultimately triggered a number of seismic events, two of which were quite significant. And that led to the moratorium being put in place. Well, here we go, nearly 6 years after the moratorium was lifted, and Cuadrilla have been bragging that they will be fracking before the end of October. But there are a number of people who have different ideas. And I think 3 months ago, this lady, Helen Chuntso, was my guest on Fracking Nightmare, episode number 116. And we discussed for almost the entire duration of that program the lack of any emergency planning by Cuadrilla and by the local emergency services in the event of a blowout or other significant hydrocarbon release. And so despite having due notice that the local community was very much aware of this lack of emergency preparedness, it seems that they've basically done nothing about it. So this afternoon, a press release was issued, and this appeared on the outstanding Drill or Drop. And here was the headline: Campaigners seek emergency court injunction against fracking at Cuadrilla's site. And so it's with great pleasure that I welcome back not just Helen Chuntso, but also Bob Dennett, who's also been on a number of previous episodes of Fracking Nightmare. So I know that you guys are absolutely beat. You've had a full-on day. Hopefully you can hear me. Can you hear me?
Yes,
yeah. Oh, thank you. Thank you. I saw you staring at the screen there, and I wondered if you could actually hear me. You've had a full-on day, and I know this is the culmination of many, many months of investigative work, Helen. And you've been working, with a team of people to not only get Cuadrilla and the emergency services to acknowledge their plan or lack of, but you've now reached the stage where the only course of action would appear to be to seek an injunction. And so why don't you talk us through the process and what you hope that this injunction will achieve?
Good evening, Ian, and first of all, thanks for letting me back on your show. And it's not quite correct what Cuadrilla have attempted to say with their media release tonight, that this is a last-ditch attempt, as you are aware, and as in fact they are aware, because they have been party to legal documents that have been passed between myself and the relevant agencies for a number of months now. It has been since July of 2017 when I sent my first Freedom of Information request to Lancashire Fire and Rescue Service to ask some questions about emergency planning at the site. I had no idea at the time where it might lead me. In fact, I expected some answers. Unfortunately, those answers did not come, and the internal review came. And following the internal review, there was an application to the Information Commissioner. And I do believe I've sent you a copy of that document, Ian, where the Information Commissioner actually told Lancashire Fire and Rescue Service that they must answer the questions that I asked, because there was no reason to suggest that giving that information to the public domain would, in fact, create a security risk. This is one of the latest attempts to obfuscate putting truth in the public domain. It's somewhat patronising to suggest that it really won't be good for you to give you the information that you need, but that is sadly the only response that is left to somebody who does not want to discuss these things with us. Unfortunately, Lancashire Fire and Rescue Service still have actually argued with the Information Commissioner about answering the questions in that Freedom of Information request, and are now seeking a tribunal by way of actually not responding some more. That was where it began with Lancashire Fire and Rescue Service. So as I was concerned that was their stance, I continued to ask questions about emergency preparedness under the Civil Contingencies Act from a number of other agencies, including...
I think I've got a slide here that you sent me through on emergency preparedness and communicating with the public. Can you actually see that, Helen?
Yes, thanks, Ian. Yes, I think that is a slide from a government consultation document telling local resilience forums how they should be interacting with the public. This is legislation from the Civil Contingencies Act, and as you can see there, I don't know if you're able to read it better than I am, Ian.
Okay, yeah, well, let me read it, because I think this is a very important document, especially, as you say, it's a guideline. And this is emergency preparedness, and it's under the heading Communicating with the Public, Section 7.6. The more information the public has access to And the better educated they therefore become before an event, the more open they are likely to be to the warnings and advice they are given at the time of an emergency. A well-informed public is better able to respond to an emergency, and this will minimise the impact of an emergency on the community. Responses to a number of emergencies over recent years have highlighted the need to encourage individuals and communities, including businesses, to be better prepared and more self-reliant during emergencies. This allows the authorities to focus on those areas and the people in greatest need. And I guess, you know, the most poignant example of the need for this is Grenfell Tower.
Absolutely. Yes, absolutely. And that has been a response that's come back to us today since the article was published in Drill or Drop. Numerous people have made reference to Grenfell Tower. The residents of Grenfell Tower raised issues with their local authority because they were convinced that there would be an accident and there would be an incident and that would cost lives, and they were ignored. And this is what Helen has found in all of her her attempts to glean information from the fire service, the Lancashire County Council, the police, the Health and Safety Executive and Public Health England. And it's also been a favourite bugbear of mine for quite a long time, since Cuadrilla's, back in the beginning of 2012, Cuadrilla's drilling manager told me that they didn't do risk assessments until they had completed drilling, because then they would know what risks they were likely to encounter, which of course we know is a load of rubbish. The whole purpose of a risk assessment is to assess the risks before you even start work, and therefore put yourselves in a situation where you can mitigate those risks. And it's blatantly obvious to me that once again this industry is trying to cover it up and not be answerable for safety concerns, except for the people on their own site. And as you are well aware, where this particular site is located, within 300 meters there are significant number of properties. Within another 500 meters there is an elderly person's park home, and within 5 kilometers there are 15 schools. And
I believe there's something like 3,000 plus pupils, school pupils.
Absolutely.
Within, I thought it was less than. Oh, that's probably about right, because I thought I had 3 miles in my head, so it's about 5 kilometres. Yeah,
that's about right. Yeah.
And there was also a mental health hospital, and it's not a term that I am comfortable with, but there is a requirement in law to actually consider what would be termed sensitive receptors and the impact of any risk assessment upon them. So in light of that slide that we discussed earlier in relation to a duty to liaise with the public, I'm just bearing in mind that if there is a fire in a restaurant, that restaurant is not allowed to open until there are relevant procedures that have been signed off that are specific to that restaurant and that have been followed. One of the things that it strikes me here is that the local schools, the local care homes, and the local mental health hospital would be called particularly sensitive receptors, and their need to actually make plans that would mitigate and reduce the harm, and in fact reduce the distress. I cannot say with my hand on my heart that an evacuation process of the local community would not be highly distressing for people with mental health problems in a hospital, or for people with mobility issues in a care home, or indeed for children. There is no way that we can say that not knowing what is happening there because you've not done a trial run is satisfactory at all. And I'm sure we'll talk about the impact on the schools later on, what we know about the schools.
Well, let's talk about the schools, because the Preston New Road is a main artery. I mean, it's not the only artery, obviously, because there's the motorway, but obviously, people need to come off the motorway to get to the schools. It's pretty much one road. There's a few sort of country lanes that they can get to. But in the event of an emergency, then obviously parents are going to be extremely concerned, and rightly so. And without any plan in place, there would be absolute chaos. as the parents of some 3,000 pupils desperately tried to get from wherever it is that they are working or living to get to the schools, yet the traffic would obviously be at a standstill because Preston New Road would, by necessity, be closed off. So I'm guessing that, I mean, I think in a previous conversation, Helen, when we talked about this back in June, we made the observation that the schools had basically, or somebody, the Cuadrilla or the fire service, had basically made the observation that the schools were responsible for establishing evacuation plans.
Unfortunately, Ian, that is correct. We are aware that the schools are acting on guidance that has been provided to them, but this actually places the responsibility for assessing the risk and the management of that risk on the school teachers. So school teachers with no qualification in risk assessment of gas ingress, of what signs and symptoms there would be of exposure to gas without knowing what those gases were. If it had been placed before me, as I had asked from the regulators, what this guidance was, I may be in a position to actually know that that was suitable. But unfortunately, parents haven't been notified and nobody's been notified. We've been told that we don't need to worry about this because somebody else has got it in hand. That may be so, and I look forward to seeing those documents and them being placed before the courts. But we haven't had those disclosed to us as would be required by the solicitors. So that causes me concern, and as a parent, that would be very concerning to me that my school teacher was actually in charge of asking my child to shelter in place, and there is government guidance on shelter in place, whilst the all clear would be given. So let's be really clear about what that would mean. We, as far, do not know what alarm systems are in place to notify the schools. One of the questions that I have asked of Lancashire County Council is, please advise me how you are going to notify the schools. So is it possible that everybody gets an email, and will the teachers be sat there watching the email? Will there be an alarm that goes off? How do the schools know that something has happened so that they can act promptly? Where is the space that the children can be safe? Is there a shelter for them that is free from gas, or are they simply going to have to close the windows and wait until they're told that they can get out? The problem that we are looking at here is that we're told that this will be based on a dynamic risk assessment of the time. I don't think that anybody's really thought about exactly what you're said now, and I, in fact, I have actually asked Lancashire Constabulary what the traffic management plan is for the day, in case that would happen.
Especially as all the schools are downwind. I mean, the prevailing winds in Blackpool come in from the west. I mean, there's odd occasions, but for primarily for about 8 months of the year, the prevailing winds come from the Irish Sea, and the schools are directly downwind.
That is an unfortunate fact and reality for the schools, but a greater problem is that the school teachers actually, to the best of my knowledge, don't have any equipment to monitor the extent of any gas ingress to the schools, which is a problem if there are severely toxic gases such as hydrogen sulfide gas, which could have lethal effects, or it could have sedative effects or irritant effects in low concentration. We simply don't know what extent that would be, and nor do the teachers. So the teachers would be the people in charge at that time, because the fire and rescue service cannot be in all of those schools at once to assess that. As the wind blows from one place to another, what situation are those children actually in real time? Who is assessing that, and who decides to evacuate them in real time? And that must be calibrated against data that is provided by the schools. But if the schools have not been given monitoring equipment, I'm unsure how they're going to actually be able to do that. This is a scientific problem that would need a scientific solution and some training of staff. It's simply not fair to ask the schools to preside over children who are hiding under the desks here.
Well, I mean, this industry, I believe, claims that the frack pad is effectively just a medium risk. Well, you know, basically everything's a medium or even a low risk until it happens.
Could I just correct you there, please,
Go on.
Ian? There actually was a meeting held last night, and we've actually received minutes and notes from that meeting, where Chief Inspector Keith Ogle of Lancashire Constabulary is stating very clearly, in spite of the fact that I have numerous emails from him to the contrary, that he actually believes that the operations on the fracking site are actually low risk.
Well, I mean that is just.
I don't think Keith Ogle's sure what level risk he's going to be policing there, but I look forward again to receiving the clarity of that from the courts as requested.
Well, of course, it's low risk until it happens. And then, you know, the order of magnitude, of course, will be way beyond what they've got any preparation for. And let me take an extreme example, because back in 2015, in October, so it's almost exactly 3 years ago, there was a massive blowout at Aliso Canyon, which is near the Porter Ranch estate in California. Now, this wasn't a fracked well per se. This was a gas storage facility. And because the amount of fracked gas was such in California, they couldn't actually sell it. They overfilled the storage, so it was at a much greater pressure than it was designed to hold, and particularly as the blowout preventers hadn't been replaced as they should have been. And that led to a 3-month blowout. Now, during that time, we had people from Porter Ranch actually live interviews on Fracking Nightmare. And we predicted what would occur in the prognosis, i.e. that once they capped the well and they declared it to be safe, the fact that, and in fact I have the actual estimate here, 97,100 tons of methane, 7,300 tons of ethane were released into the atmosphere, along with multiple other gases. And the observation that was made at the time was that the effects, the negative health effects, would be felt long after this well had been capped. Because Porter Ranch, a community of some 7,000 properties, was downwind, and a lot of this gas would seep into homes, would embed itself within the carpets, within the curtains, within the soft furnishings, within clothes that were in the wardrobes. And 2, 3, 4, 5 years down the road, the negative health impacts would start to manifest. And guess what? Medical practitioners in the area who had never considered the possibility of negative health effects after the well was capped are now reporting very, very significant negative impact on health. And this, on a lesser scale, has also been the experience of communities that have had the misfortune to experience blowouts across the US over the past 20 years or so, since the unconventional hydrocarbons industry effectively manifested. So to claim that this is low risk, especially with Cuadrilla's track record, is incredibly naive, and I'm being generous when I make that observation.
I think there might be a very clear reason why it's been determined to be anything other than high risk. Maybe we should discuss the Local Resilience Forum a little bit. The Local Resilience Forum is the body that is actually charged. The Lancashire Resilience Forum is supposed to be overseeing emergency evacuation plans and civil contingency plans here. What we actually have is a non-statutory body. I don't know if you actually got, I'm not sure if Lancashire Resilience Forum know whether they are a statutory body or not, because it was actually only a couple of weeks ago when I questioned this because of a response that I got. Lancashire Resilience Forum actually had up on their website that they were a statutory body, but I now have it from them that they aren't. So again, I look forward to seeking clarity from the courts as to whether this public body, which is in charge of civil contingency planning and people's lives, actually has a legal standing, and what course of action can be taken against it if it fails in its plans. This is what we're testing here. Lancashire Resilience Forum, who are you? You're comprised of several Category 1 responders, but each of you has a duty, and each of you has a duty that has been examined and we've found you wanting. So each of you will actually be examined in turn, and then we will have to determine who is responsible.
Precisely. And I mean, this is what everybody's doing right now. It's not my responsibility, it's theirs. And you know very well what's going to happen when there is a disaster. Exactly. And you know, they're going to have the inquiry. And by the way, whatever happens, there will always be less than 100 deaths. I have it on very, very good authority from somebody who basically is firsthand, that the number of deaths at Grenfell Tower was in excess of 100. But do you know why they always report? You think about incidents, and I won't name them, but you think about incidents that have occurred, and the number of deaths reported is always less than 100. And the reason for that, apparently, is that if there is more than 100 deaths, there has to be an inquest. So they always state that there's less than 100 deaths to avoid the public inquest. So you know what's going to happen here, regardless of, you know, a massive gas leak or gas cloud or whatever. You know, it's effectively an airborne version, God forbid, but an airborne version of Aberfan. You know, obviously, you know, Bob, you will remember Aberfan very, very clearly, 1966.
Clearly.
An avoidable incident, a clearly avoidable incident where everybody did this. Now, obviously, there was physical result of that because of the tip. But with this, obviously, it's invisible. And the effects might not necessarily impact all in one go. It'll build up over a period of time, which, of course, also gives them plausible deniability. But it's this. And then whenever they do have to admit that there's been an avoidable incident, they come out with the stock phrases of lessons have been learned. No, nobody gets anything more than a slap on the wrist, but lessons have been learned. And this is the catch-all in this kind of situation. And, you know, Helen, what makes this even more outrageous from my perspective is we know that this industry monitors our social media 24/7. They are paranoid about the anti-fracking community. And they have good reason to be paranoid about the anti-fracking community because we are on every single move they either do or don't make. But they are monitoring our social media, and we have given plenty of notice that we are aware of these deficiencies. I mean, you've only got to take a look at episode 116 of Fracking Nightmare, where we talked about exactly this issue. And my concern at the time was that we might just be giving them a heads up. But hey, nonetheless, ultimately, of course, you know, there's a responsibility to the community. But they've done nothing since then. And I mean, you know, some of these screenshots that you sent me through, I mean, unfortunately, they're in no particular order because I literally just had to download them and throw them up. But so maybe work through them, and I apologise if they're not in any sort of coherent order. But let's take a look at this. This is a guide to borehole sites and operating regulations from 1995. So this is, once again, a prima facie proof that we do not have any specific regulations in this country for unconventional gas exploitation. Because in 1995, the unconventional gas industry didn't exist. So this is a borehole regulation that applies to effectively conventional wells. But as we know, the unconventional process is very different, primarily in terms of high volume and high pressure. But, you know, you have the observation here, site planning and design. Fires, explosions, blowouts and gas escapes and the necessary measures required to control risk from these hazards and to facilitate escape and rescue should be addressed at the site design and planning stages. At the planning stage, the local fire and rescue service should be consulted on both operational firefighting and fire safety matters, including provision of suitable water supplies and access for fire appliances. And of course, it won't escape anybody from Lancashire watching this that on the first week of August, United Utilities were on the brink of announcing, well, they did in fact announce that they were intending to initiate a hosepipe ban, but they eventually rescinded it. And I believe that they rescinded it under some pressure from elsewhere, because to implement a hosepipe ban in the northwest, just as Cuadrilla were about to unleash their frack fluid on the geology, would have been a bit of an own goal. So, and if you look at the reservoirs in the northwest right now, they are extremely low. So, in your opinion, how much of this guidance, as issued by the Health and Safety Executive in 1995, is actually in place?
With the greatest of respect, in my opinion, as Cuadrilla will probably tell you, isn't worth anything. In fact, my opinion isn't the point here. What that regulation there refers to is that there is a requirement for the Lancashire Fire and Rescue Service to be consulted at the planning stage. This is the nature of what I asked Lancashire Fire and Rescue Service. Please answer yes or no. Were you consulted at the planning stage? Why do Lancashire Fire and Rescue Service not want to answer me that? It's very simple, and a yes or no answer would have actually sent me away in July of 2017, but sadly here we are over a year later in the courts. Why is it that United Utilities have set forth their solicitor to respond, or fail to respond, to be more to the point, about suitable provision of water? The Fire Services Act 2004 requires that it is made clear to Lancashire Fire and Rescue Service that there will be adequate water. So I would go away very happily and get back on with my life, and then you wouldn't need to ask me for my opinion if they were kind enough to offer me their opinion and some facts on were these things in place. That's all I would like the public to know. I would also like to know this, and I would like to ask this question of Michael Gove in his capacity as a minister. If there is to be an unconventional oil and gas industry unleashed in this country at times of water stress, what is the hierarchy of provision of water in times of need? Who will get the water first? Are you going to turn the tap off for homes and businesses first? Are you going to turn the tap off for companies such as Cuadrilla who are fracking first? Where does the Fire and Rescue Service come in that hierarchy at times of water stress for water requirements for firefighting in regard? The Fire Services Act 2004. Do you save it in one reservoir or one bucket over here? And then when it gets a bit low, I just need to know these things, or more to the point, I need to know that they know them. If they would be kind enough to furnish us with that information, as has been requested by our teams, then again, we could all go back to our lives. This is simply a matter of the regulators being able to confirm to us that they are in fact doing their job. But as you pointed out, there appears not to be a shale gas regulator who is able to do any of this joined up thinking. I'm not available for the job, by the way, if any of you are thinking of offering it to me. You couldn't afford me and I would be unwilling to do the work for you. I'm inviting you to do the work yourself. And in the post for shale gas regulator, that post should not be open to somebody to actually sell it and PR it to the community. I'm talking about somebody who's in charge of health and safety here. I am willing to give you some pointers on what you should do. And if you follow the proceedings that have been issued in the courts today, you may actually get some insight into what it is that you should have been doing for the past year or more.
Well, actually, we could put you into that job because you would only be in the job for about 3 hours, because you could close this industry down in a heartbeat. You know, one of the things that also they're not addressing is the EU Water Framework Directive. Sorry, that shouldn't be on screen, Mike, because the EU Water Directive, which, of course, because it's effective EU, has precedence over UK legislation, but the Environment Agency makes a small reference to it, I believe. But here's the opening paragraph. Rivers, lakes and coastal waters are vital natural resources. They provide drinking water, crucial habits for many different types of wildlife, and are an important resource for industry and recreation. A significant proportion of them are environmentally damaged or under threat. Protecting and improving the environment is an important part of achieving sustainable development and is vital for the long-term health, well-being and prosperity of everyone. The European Community Water Framework Directive is a welcome and radical improvement on earlier piecemeal EU water legislation. It expands the scope of water protection to all waters and sets out clear objectives that must be achieved by specified dates. Now, the responsibility for ensuring that the EU Water Framework Directive is followed in this country rests with the man you just mentioned, the Environment Secretary, Michael Gove. So we don't hear the EU Water Framework Directive being mentioned very much, either in Parliament, by the industry, or even by actually the anti-fracking community. And maybe it's time that people in Lancashire actually started to do some research into the responsibilities contained within the EU Water Framework Directive, because in my opinion, based on what I know of the EU Water Framework Directive, the fact that the unconventional gas industry is even allowed to be considered actually goes against the guidelines of this directive, particularly in a country such as ours, which is absolutely dependent on the natural water cycle.
It's an elemental matter, isn't it, Ian? We need to look at how we control and mitigate the effects of fire. We need to look at what water usage is and how we might be able to safely and carefully monitor and make sure that its use is available to all people at times when water will be the most precious resource that we have, not gas. It will be water. We need to just look at basic things, and I do think that this is an opportunity to examine how our resources are used rather than owned and abused by corporations.
Well, the knock-on effect of this, of course, is that, we hear the sociopathic oil and gas industry and their sociopathic representatives, the Oil and Gas Authority, of course, which the sole shareholder is Greg Clark as Secretary of State for Business, Energy and Industrial Strategy. We hear a constant reference to energy security, but we have a major issue with food security in this country. And in fact, our food security is less than 50%. More than 50% of our food is imported in this country. And the other issue is that we also are very, very high on the league table of consuming processed foods, but that's perhaps another debate. But, on the basis that our agricultural industry is absolutely reliant on the quality of the water. And I mean, I give an example, just the other side of the country, where iGas have, of course, still got their injunction in place. But one of the largest organic farms in the UK, Polybell, which provides organic produce to all of the major supermarkets, and they are within a mile of the well site at Misson Springs. So if anything goes wrong there, which of course it will, then the likelihood is that not only will Polybell lose its organic status, but actually the soil will be totally incompatible with growing uncontaminated crops. And of course, this is exactly what we're seeing in places like California now, where there are massive problems because of the volume of produced water from these fracked wells. They're actually using the untreated produced water for irrigation. And I mean, this is an extinction event. I mean, it's the destruction of the food chain. Now, people say, oh, that's California. But, don't think for 1 minute that what is currently applied in places like the US and Canada and Australia wouldn't creep in here if this industry got a foothold. So there is really, I mean, you have opened the door here. You haven't just opened it a crack. With the work you've been doing here, you've stuck a boot through it. And now the onus, I hope, is on people, not just in Lancashire, but all around the country who live in these targeted sacrifice zones, to look at things like the Water Framework Directive and get on to their elected representatives. And, you know, I have to say that the Permitted Development campaign has been an absolute godsend for the anti-fracking community, because it's really brought the message home to many communities that, you know, were completely oblivious through their willful ignorance. And, you know, with councils now voting almost unanimously to reject the proposition for unconventional gas exploitation to become permitted development, you know, we really have this industry on the back foot. The lid of the coffin is in place. It's time to ram the nails home.
That's only possible if people are aware of what is going on. And earlier in this interview, Ian, you asked me what my wish and my intention for this was. My wish and my intention for this is simply to place this awareness before people, because it appears to have been hiding in dark corners. We must shine a light on the basic facts of this industry, and seek the truth of what impacts it will have on communities, because I actually think that there is a deliberate effort going on here to not discuss the basic reality that when you invite an onshore hydrocarbon production industry right into the heart of communities, that there may well be effects that are so adverse that you will need to evacuate yourself from your home for a few hours, a few days. This is something that must be conversed with, as is a legal requirement under the Civil Contingencies Act, and as is in fact common sense. There is something very indecent about the fact that that this hasn't been discussed already, and that it's actually taken numerous requests and a promise of legal action to actually make anything happen on this. There's something really frightening about the fact that this industry was about to start fracking within a matter of days, at a time when the schools were not aware and parents were not aware of what would happen. That is terrifying.
I think the use of the word indecent is somewhat generous on your part. I mean, it's fundamentally immoral. But, you know, why are we not surprised? Because as we have observed on many occasions, this is an industry that works on the principle of it's a lot easier to ask for forgiveness than it is for permission. And, you know, Grenfell Tower should have been a massive wake-up call. But, you know, this industry works on the principle of, oh, no, it couldn't happen to us. And yet, unfortunately, of course, they prove time and time again that they are incompetent, that they have total disregard for regulation, and they simply will just ride roughshod, and then when something does occur, they'll say, oh dear, what a shame, we're very sorry, but lessons have been learned. Let's have a look at Cuadrilla's response. I'll come back to you, Bob, in a second. Cuadrilla said in response to the awareness that this judicial review was being launched, it said, we remain confident that we and Lancashire County Council have undertaken all necessary risk assessments and have thorough emergency response safety procedures in place. This is clearly a last-ditch attempt at delaying our efforts to find a new source of much-needed natural gas. Don't you love the way they spin the terminology? For the UK, which is a national imperative, we consider the grounds for judicial review are hopelessly weak and will vigorously defend any call for an injunction. I mean, this response, you know, borders on the puerile. And in fact, you know, whomever it was that put that response out, I doubt they have the first clue about the industry, because obviously it's come from some PR walla. But, you know, they should be held to account. They should also be pulled before the courts to explain such a statement when it is a flagrant lie. And, you know, I put the observation out to Francis Egan as the chief executive officer of this particular cowboy outfit. I would relish the opportunity for you to accuse me of slander or libel and drag me into the courtroom, because in the cross-examination, you would be exposed for the sociopath, the ignorant sociopath that you and your fellow CEOs in this industry truly are. Sorry, I'm holding back a bit. I'd like to say what I really think, but that's about as far as I can go right now. Bob.
I think it's very interesting, by the way, to whoever actually wrote that press response, that Cuadrilla have actually got the energy to vigorously defend something that is so hopelessly weak. I wouldn't bother to vigorously defend something that was hopelessly weak. But again, we look forward to, by the way, Cuadrilla, we look forward to the HSE's response and your response to these disclosures. And
we look forward to meeting them in court. You covered what I was going to say in this particular, this Cuadrilla's release here.
But of course, they won't be in court, because what they do is they send the legal teams in, and the legal teams are effectively responding on the basis of hearsay. And what we have to do is we have to break through this and actually get these sociopaths in the courtroom. I mean, even if the judiciary err on their side, which is what tends to be the case, as we've established, commerce in this country has absolute precedent over human health and well-being. But nonetheless, there would be sufficient public presence in the courtroom to witness their lies and their deceit. And they would have no choice but to perjure themselves, which is why they don't come to court, and it's why they never write witness statements. They always get a solicitor to write a witness statement on their behalf, because that's plausible deniability, and this is what we have to change.
Yes, we do. And as we experienced in July, Ian, their witness statements are just lies, exaggerations, and that's what they rely on, and they get away with it. Well, the work that Helen has done and what's taken place today is turning the tables on them. It's our turn now, and it's them that have to answer to us, not the other way around, as you and I have experienced in the past.
Absolutely. And, the call here is for the genuine campaigners in Lancashire to get behind Helen and Bob and the rest of the team that have managed to get this injunction. Well, they haven't got the injunction yet, but to get this request for the injunction and to put Cuadrilla on the back foot. And obviously, those people who have put their liberty on the line by participating in the direct action this week have all contributed to the delay process. And obviously, the longer the delay, the more the opportunity to perhaps even take this injunction to a whole other level. So, Helen, amazing work. And Bob, thank you for stepping into the frame here as the defendant on this, or the applicant on this for the injunction. And I believe that if justice is going to be done, then Greg Clark, as Secretary of State for Business, Energy and Industrial Strategy, has absolutely no choice other than to instruct Cuadrilla to stand down pending a full inquiry following this injunction. And let's see what comes out of that. But everybody needs to be on this, and the people of Lancashire need absolutely to get behind Helen and Bob. Any last word, not last words literally as it were, but any final words for this evening, Helen?
Thanks, Ian. I'd just like to express my heartfelt gratitude to the legal team, who have been absolutely phenomenal in working behind the scenes for a period of months. This is not a last-ditch attempt, as we all know, including Cuadrilla. But yes, I'd like to thank them for phenomenal work in bringing this to the courts.
And of course, we can put not just Cuadrilla, but the rest of the industry on notice that basically we'll just keep coming at you. And, perhaps I should also mention, of course, that there's two other challenges going on elsewhere in the country. Paul Andrews, the mayor of Morton and Norton in North Yorkshire, he is in the process of calling for a judicial review following the ministerial statement earlier this year, which of course has led to the consultation on permitted development. And I think literally in the last few days, there's a resident of Hart Hill that has also managed to get permission to pursue his judicial review against the planning process that was adopted to grant INEOS permission to drill at Hart Hill. So, you know, this is the beauty of the anti-fracking community. It is a hydra. It's multi-headed. In fact, you know, there is no coordinated plan. It is simply a case of everybody doing whatever it is that they feel they need to do to protect the ecology and the environment of this country for future generations. So, Bob, any final words then?
No, I just concur what Helen has said, but I'd also like to thank Helen for all the endless hours of work that she's put in on this. I've come into this right at the very later stages, and Helen's been working on this for an extremely long time, and I know she's absolutely exhausted. And hopefully we will bring this to some form of conclusion within the next week so that she can get some rest.
Absolutely, well-deserved rest. So, yes, I do hope that Francis Egan is having an extremely sleepless night. And I hope that Greg Clark is also having a sleepless night. Claire Perry, of course, is just incapable of actually comprehending the magnitude of what's occurring here. So I'm sure she will sleep extremely well until that circus arrives on her front lawn. So, guys, thank you so much for everything you've been doing. I do believe that there is potentially going to be a crowdfunder to help finance this. And as and when you have the details of that, obviously we'll link that beneath the YouTube of tonight's program.
There is a link to that crowdfunder on the Drill or Drop site with the article that Ruth Hayhurst published this afternoon.
Okay, in which case we'll put that link under the video when it goes up online. So,
can I also send my thanks out to the local community who actually very quietly and very diligently worked with me on this. You know who you are, and I'd just like to say thank you for the welcome in your community and your solidarity, and for recognising that there is a need to work together at these difficult times, and to bring this case to the court. Look what we do when we work together. It's been a pleasure to work with you. You know who you are.
When we work together and we ignore the dramas, absolutely. Guys, thanks so much, and thank you all for joining me and Helen and Bob this evening. And so here we are, nearly 6 years after the moratorium on unconventional gas exploitation was lifted in this country, and Cuadrilla, who still probably think that they're on the cusp of fracking before the end of the month. But I think that even if this judicial review doesn't get granted, there's something else in the wings to follow it up. So watch this space. Take care, and I'll see you in a few weeks. But I will be back with a live stream at 8:30 a.m. tomorrow morning. Take care now.